Hello to everyone who's joined us and welcome to this, our latest webinar. Today we're going to be discussing our consultation on our financial penalty fining regime and proposals that we're currently consulting on updating those proposals. Before we get into the webinar and I introduce our speakers, for those of you who maybe haven't joined one of our sessions before, we want to make these as interactive as possible. So what we'd really like to do, as well as telling you all about the proposals, is take your questions. It's really easy to submit a question. So under the video, which you'll be looking at, you'll see a link. If you put your questions in there you have for the panel, we'll endeavour to get through as many as possible as we go through the webinar. Please do try and get them in as you go along, as you think about them. So later on in the webinar, we will pick them up. So don't worry if we go past the subject you wanted to talk about. This stream will be available on our catch-up service afterwards, as will the slides and other resources which we'll be referring to in the webinar. So if you find this interesting, please do share it with your colleagues. First of all, I'd just like to introduce you to our speakers. My name's Simon. I'm the Head of External Communications at the SRA, but more importantly are our experts. So we have Jackie, who's our Head of Regulatory Policy, and we have Kieran, who's the Knowledge and Development Manager in our investigations team. I'll be coming to each of them shortly with some questions. So in this webinar, we're going to be discussing the proposed changes we want to make to how we set and issue financial penalties in cases of misconduct. As I say, we're consulting on this. At the end of the webinar, we'll bring up some details about who you can get involved and give feedback on these proposals. It's out for consultation until the 20th of September, and we genuinely do want to hear from you. So please, if you find this of interest, if you've got any thoughts, look at the links below the video and let us know what you think. So before we get into the proposed changes, I'd just like to bring in Jackie. And Jackie, perhaps you could briefly describe what our current approach to setting and issuing financial penalties is, and perhaps why it is we're looking to make potential changes to these.
Yeah, sure. So we introduced our current approach to determining the appropriate level of financial penalty in May 2023. The aims of those changes at the time were to resolve cases more quickly, reducing cost, delays, stress to those subject to our procedures, as well as reducing cost to ourselves. And secondly, improving public protection and providing consistent outcomes which deliver a credible deterrent to the future risk of repeated behaviour. As part of those changes, we sought and received a rise in our fining powers in relation to traditional firms from £2,000 to £25,000, which was central to implementing those changes. Some of the key changes that we made at that time was we introduced new fining bands and a new schedule of fining bands. For the first time, fines were linked to income for both firms and individuals in all cases. It was the first time that we'd linked fines to income for individuals and for certain firms. We introduced a fixed penalty regime for administrative and lower level breaches of our rules, and we clarified our approach in relation to misconduct involving sexual harassment, sexual misconduct, discrimination and harassment, and made it clear that we didn't think that a financial penalty would usually be appropriate where that misconduct involved an individual. So to briefly explain how we currently determine the level of the fine, our existing framework comprises of 4 penalty bands, which are A to D, with A being the least serious misconduct that's suitable for a fine, and D being the most serious misconduct that's suitable for a fine. And then fines are calculated as a percentage of a firm's annual domestic turnover or an individual's annual income in the majority of cases. And the basic penalty scales illustrated in those fining bands range from 0.2% for firms up to 5%, and from 2% to more than 97% for individuals. Our process, once we've decided that a fine is an appropriate sanction, the process begins by categorising the severity of the misconduct and by considering the nature and the impact or potential impact of this misconduct. And then we consider aggravating and mitigating factors to arrive at an appropriate fine. There's then the possibility of discounting the fine if the individual or firm makes an early admission, had remedied any harm caused, and or if they cooperated with our investigation. So they may see a further discount there. In terms of why we're consulting now, and people will notice that it's not been that long since our new approach came into force. And so since March this year, we've had new powers to impose unlimited fines for misconduct related to economic crime. And that prompted us to revisit our fining guidance. And that was something that we made clear at the time of introducing the new approach in March 2023. But we thought that it was sensible while we were reviewing that in light of those new powers to reflect on the new approach and take the opportunity to update our guidance in light of our experience of operating that framework since March 2023. And one of the areas in which we've taken the opportunity to clarify our approach is in relation to penalties linked to drink driving offences.
Thank you, Jackie. So before we get into the detail of the proposed changes, just at a very high level, there are four broad areas we're going to discuss today. So the first one is, Jackie talked about the fining bands, so we'll explain the higher fining bands we're going to introduce to try and give a bit more transparency for those fines at a higher level. We're going to talk about minimum fines at all bands. We're going to touch on updating our approach to how we consider impact of misconduct and the aggregated and mitigating factors. We're going to talk about clarifying how we determine income in some cases, and also we're going to touch on what our approach we're proposing is going to be, where we're issuing a fine, where there's also been a financial gain accrued by the perpetrator of the misconduct, and what our approach in that area is going to be. So, Jackie, if we can go through those one at a time. So the first proposal is to introduce two new fine bands, E and F, which would apply for more serious misconduct. Could you briefly explain to us how those will work?
Yes, certainly. So it's really important to make it clear that our published guidance does not fetter the discretion of our decision makers, and they are able to impose fines now up to our statutory limits. And so that means that our decision makers may impose fines that are above the figures that are currently published in those bands that we have now, A to D. But in most cases, because of our statutory limits, that would result in a fine in excess of £25,000. And so for individuals and traditional firms where our limit is £25,000, we would need to make a referral to the SDT, the Solicitors Disciplinary Tribunal. And individuals and traditional firms make up the majority of our regulated community. But the Economic Crime and Corporate Transparency Act changes that. Where we impose fines for very serious misconduct using powers under the Economic Crime and Corporate Transparency Act, we won't need to make that referral to the SDT anymore. So as such, it's likely that fines imposed at more than the amount set out in Band D of our fining frameworks, that's 5% for law firms, it will still be uncommon, but it will be more frequent in the future. The legislation will have less impact on alternative business structures because we already have powers to impose fines of up to £250 million on the firm itself and £50 million on the individuals who work for them. But so we think it's really important that we update our published fining guidance to cover how we'll determine the correct level of the fine in those cases where it exceeds Band D, and that will provide more clarity for those subject to our decisions, and it will also help our authorised decision makers to identify when a fine of more than 5% of a firm's turnover or more than 97% of an individual's income is appropriate, and if so, what the appropriate level of the fine might be. So in our consultation proposals, Band D fines would range from 6 to 10% of a firm's annual domestic turnover and 113% to 145% of an individual's income. Band F will be for fines that are higher than those percentages, and they will be applicable to the most severe cases that are suitable for a fine.
Thank you, Jackie. And another area regarding fine levels in the consultation proposals is introducing minimum fines at all banding levels. Could you just explain what we're proposing in that area, please?
Yeah, sure. So we need to ensure that fines are imposed at the right level to provide a credible deterrent and to uphold public trust and confidence in legal services. And that's the reason why we're proposing to introduce minimum fines at each of the bands. We're proposing that the minimum fines would rise as you go through the bands, starting at £5,000 for firms and £2,500 for individuals, and then up at band F to £500,000 for firms and £100,000 for individuals. They're intended to reflect the seriousness of the misconduct and make sure that those fines act as a credible deterrent. It may help if I illustrate how that came into sharp focus to us. So one of the changes that I mentioned earlier that we introduced in 2023 was to introduce fixed penalties for low-level and administrative breaches of the rules. And if a fine was calculated as a percentage of a firm's turnover or an individual's income, it can result in a fine that's lower than a fixed financial penalty, even though the misconduct must be serious to even be fined in Band A. So we are very alive to the fact that minimum fines will have a greater impact on small firms and individuals with lower income because they will represent a larger proportion of their annual turnover or of their annual income. Our current fining guidance now provides for decision makers to adjust an indicative fine to consider affordability by the paying party. But what we're proposing is to make that a more explicit step in our new guidance, and we will specifically invite firms and individuals to provide representations on their ability to pay a recommended fine. And those representations will be taken into account by decision makers when they determine the final fine amount. As a general guide, decision makers will need to be satisfied that the fine could be paid within 5 years.
Thank you, Jackie. Kieran, turning to you, we're proposing a more prescriptive approach to how we determine specific levels of fines, especially in terms of how we measure and consider the impact of any misconduct. And perhaps you could just explain to us the approach outlined in the consultation in that area.
Yeah, sure. Thanks, Simon. As Jackie's already explained, our current guidance when we're calculating financial penalties takes account of the nature of the misconduct and the impact of the misconduct, and any potential impact as well. And we do this by applying a scoring mechanism which is set out in the current guidance. What the consultation now does is it develops that further. It outlines changes to the scores that we will be using going forward. And the purpose of this will be, it will support transparency in our decision making. So when we are imposing fines, we're recommending fines, we're setting out our justification for financial penalties, we will be able to apply a more prescriptive approach in terms of the factors which are being taken into account when we are determining the particular band that an impact might fall within. So the types of things that we will take into account when we are calculating an impact score would be the number of clients impacted, whether the impact was financial or non-financial, whether there's wider societal impact, and the duration of the misconduct as well. So again, that will demonstrate that there will be a consistent approach to how those impact scores are being calculated, and that will be set out in any notifications which are sent out to the relevant individuals. There will also be a small change to the nature score. So the current nature scores in our current guidance are using a score of 1 and 3. These will now change to 1 and 5, and that is to reflect the importance of the nature of the misconduct as well, and to make sure it has a sufficient holding in the calculation of the financial penalty as well.
Thank you, Kieran. And another area we're proposing when we publish to look at is new guidance on how we take account of the aggravating and mitigating factors Jackie touched on earlier that help us get to the final fine level consideration. Could you just explain to us what we're proposing in that area?
Yeah. Sure. Again, this builds on the current guidance that we have. So as Jackie explained, we do have a process currently. So for taking account of aggravating and mitigating factors, which will be specific to an individual matter that we're looking at. So you would have your nature and impact score calculation, and then we would take account of aggravating and mitigating factors. What we are finding is that the current position is complex. It can sometimes cause inconsistencies in the factors which are being considered, and there is a concern that it could undermine trust and confidence and the deterrent effect of the financial penalty, which is the objective that we're trying to achieve with these. So the proposal going forward will be that the new financial penalties guidance will set out a non-exhaustive list of aggravating and mitigating features, which will be taken into account before we arrive at the specific financial penalty recommendation. And again, this goes some way towards ensuring that we are being completely fair and transparent in terms of how that financial penalty has been calculated. That will be set out clearly in accordance with the guidance. Any representations which an individual or a firm might wish to make in relation to those can be set out in a consistent way, so we can make sure that we're applying those factors in a consistent way. The other slight deviation from the current guidance is going to be that we won't have the adjustment factors which Jackie spoke about. There will not be a discount for meeting a regulatory obligation, which an individual or a firm would be under an obligation to meet anyway. So these any factors which are relevant to a specific case will be taken into account as an aggravating or mitigating factor. And some of the aggravating factors that we have listed are things like a lack of insight, a lack of remorse, harm to a vulnerable individual, hindering an investigation, a failure to cooperate. And on the other side of it, mitigating factors would be things such as taking steps to prevent further misconduct and making early admissions. So again, it's front loading that transparency in terms of the factors that we will be taking into account when we're calculating the financial penalties.
Thank you. And again, one of the things Jackie referred to earlier was when we calculate the percentage, we then obviously look at income. And in this guidance that we're proposing, there are some cases where I guess the core metric of income is not net and turnover is not necessarily the right metric to consider, and I think the guidance we're proposing sets out a bit more detail about when that may not be the case.
Yeah, that's right. Again, our current guidance envisages that we use domestic turnover or for firms or annual income from legal work for individuals. The current guidance does allow different matrix to be used in exceptional circumstances to ensure that a financial penalty has the deterrent effect that we need it to have in order for it to be an effective sanction. But what we are proposing to do in the new guidance is to set out prescriptive examples of when it might not be appropriate for us to use the domestic turnover or the annual income from legal work. So that might be, for example, if we have a large international firm which has a very small presence in England and Wales, if we were to calculate a financial penalty based on domestic turnover from England and Wales, the financial penalty may not be a sufficient credible deterrent. So we may look at alternative options in terms of how that financial penalty might be calculated. And again, in terms of individuals, and this is set out in the consultation and will be illustrated in the guidance as well. For an individual, it might be that an individual has a very small income from the legal work that they do, but they have a very large income from other business interests. And in those cases, the guidance would allow the flexibility to take account of or to apply other metrics when we're calculating financial penalties.
Brilliant, thank you. Now, there are cases, aren't there, where sometimes we're issuing a fine where actually the misconduct has also resulted in financial gain for the subject of the fine, and the new guidance clarifies what our approach will be in those areas?
It does. It does. So our current guidance states that a fine must adequately eliminate financial gain or other benefit obtained as a direct or indirect consequence of the misconduct. And the new guidance is more explicit in relation to this. So it is more prescriptive, and it says all financial penalties will be the sum of the indicative fine and amount of any financial gain or other benefit that resulted from the misconduct. So what that will mean in practical terms is where we have an indicative fine of, say, £8,000, but the firm has gained £10,000 as a result of the misconduct, the final financial penalty will be at least £18,000. It wouldn't be appropriate for us to raise the indicative fine to £10,000 to match the amount of the financial gain, because the financial penalty which has been calculated when we're taking account of the nature and impact scores isn't reflected within that. So the financial penalty that we calculate will sit above any financial gain that the firm or the individual have made as a result of the misconduct. So again, our current guidance would allow for this, but the new guidance will explicitly set this out.
Thank you for that. Now, we've had a question, and we actually cover this in the consultation, about what the new guidance says about our approach to drink driving cases, which is an area we quite often get a lot of queries on our approach, and it sets it out a bit more explicitly what our approach is in this area, I believe, Kieran.
It does. And I think I would, whenever we're discussing this topic, and our current topic guide and the new topic guide, which is an annex to the current consultation, starts by saying drink driving is a very, very serious criminal offence, and we don't deviate from that at all. It is a very serious criminal offence. It is dealt with as it should be, appropriately by the criminal courts. However, we do feel that there is a role for the regulator to play in this, because all convictions have a clear impact on public trust and confidence in the profession, and we would say that drink driving falls within those. We have reviewed our position on drink driving convictions and how we approach them, and how we might consider those going forward, which is set out in our new in the updated topic guide, which, as I said, is an annex to the consultation which has been published. And what we also set out in the consultation is that going forward, we will not issue financial penalties for misconduct resulting from convictions for drink driving. We consider that the majority of these matters will be dealt with by way of a rebuke or a warning from the SRA, but the most serious cases, where there are aggravating features and it may not be appropriate for us to issue a rebuke or a letter of warning, may result in a referral to the tribunal. And again, the consultation sets out examples of when a matter might be referred to the tribunal, so what those factors are, which would mean a matter is so serious that it's appropriate for us to refer the matter to the tribunal.
Thank you, Kieran. So just a reminder to anyone listening, if you have any questions, please do get them in. I'm keen to cover anything you want to ask as well. We obviously have our experts here who can give you the answers to those. So you can put them in anonymously. You don't have to put them by name, but if you get them in, and we'll try and get to them as soon as we can. So Jackie, we've had a couple of questions, and maybe you can cover both of these off in one, really. So people are asking, when do we anticipate this new regime will come into effect? And then in particular, when it comes into effect, what will be the implication for investigations and cases which are ongoing, which started before that date but haven't necessarily concluded? How will we decide under what regime, I guess, we're looking at each case?
Yeah, sure. And so in terms of implementation of the new approach, we're out for consultation until I think it is the 20th of September. And then we'll take some time to consider any responses that we receive to the consultation. And then we'll return to our board, make our recommendations as to our final positions. And then we need to whatever approach we decide in the end will need to be approved by our own regulator, the Legal Services Board. So we are looking into the early part of 2025 before we implement this new approach. In terms of what impact that has on open cases, we will apply the same approach as we've applied previously when we've brought in a new approach to fining, which will be that it will apply to all open cases, with the exception of those that have reached a certain point in our processes. So if the firm or the individual has already received a sort of the notification or a letter from us that set out how we intend to deal with that case and what we recommend that financial penalty to be, or that case is being referred to the SDT or being referred to an adjudicator with the recommendation of that fine. And then we won't unpick that, and it will carry on under the current approach that we're operating. But if it's an open case and it hasn't reached that stage, then we will apply the new approach. That is regardless of when the misconduct occurred, with the exception that if we want to use our new powers under the Economic Crime and Corporate Transparency Bill, they came into force on the 4th of March of this year. And so the misconduct needs to have occurred after that date in order for us to apply those unlimited fining powers.
And actually, Jackie, that touches on another question we've had here, actually. So we've been asked about, in terms of our unlimited fining powers or increased fining powers from the previous regime, when in effect we will start enacting that power. And I think there's an interesting distinction there between having the powers and this consultation more being about giving a bit more transparency, I guess, to how we're applying them. Do you just want to explain the distinction?
Yeah, absolutely. So it is in force now, the Economic Crime and Corporate Transparency Act, and we have those unlimited powers in relation to breaches involving economic crime. But we have committed that we will consult on our approach and have our approach approved by the Legal Services Board before we implement it. If the misconduct occurred before the 4th of March 2024 and involved economic crime, we will still apply the new approach once it's implemented. But it means that we wouldn't be able to issue an unlimited fine. So if, for instance, the misconduct involved a traditional firm and it involved economic crime, but the misconduct occurred in January 2024, we would apply the new approach and it may come out with a fine above £25,000, and we would need to make a referral to the SDT rather than impose that fine ourselves.
And in terms of the consultation, I think it's probably worth mentioning at this stage that, as Jack has mentioned, it runs until the 20th of September. It's a consultation we generally want feedback. So if you have any thoughts, please do go and read the details of the consultation and let us know what you think ahead of the steps Jackie discussed, finalising the proposals for our board and applying to the LSB. We generally will be considering the feedback we've already had from various people, but any that come in the meantime to that point. So perhaps if I give one more call for any more questions anyone's got before we finish off. I mean, was there anything else, Jackie, you thought you wanted to mention that we haven't perhaps touched on in the webinar? There are lots of in the consultation, there are some good case studies out there, specifically of how some of these things might apply in illustrative examples, and they really help explain, I think, the process.
Yeah, definitely. I mean, I recognise that we've gone through quite a number of changes today, and you sort of they stack up to an overall approach. And so what we've tried to do in the consultation, and you'll find it really close to the end, is we've published some case studies that cover each of those finding bands, that cover all of A to F, to really illustrate sort of the types of cases and the behaviours that will fall into each band, but also taken really step by step as to how the appropriate level of fine will be calculated in that particular case. So I would encourage you to have a look at those case studies, because it just really brings our proposals to life.
And I think the other thing perhaps worth mentioning is we introduced our new publications policy a couple of years ago, which we try to, when we issue a fine and we publish details of an outcome, explain in plainer English how we got to the outcome and the fine level. And so a lot of what we've talked about today will spell out, won't we, in some of those decisions. So again, it's transparent and people can see how we're applying them consistently. And I think that's an important feature, isn't it?
Yeah, definitely. And we have a new decision template that we've been using for a little while now, and we tested to make sure that it's completely transparent and everybody should be able to see when they read our decisions exactly what the misconduct was and how we considered it in terms of the level of seriousness and how we came up with that final fine amount.
We've had a couple of questions in about some specifics of what may or may not be considered an aggravating factor or a mitigating factor. A lot of that's spelled out, isn't it, in the topic guides we already have online, in the consultation. So I guess the best thing is people have a look at those. Is it, Kieran, if they want to consider, because they do spell out in a bit more, I guess, bit more tangible detail what some of the sort of examples may be.
Absolutely. The topic guide would be the best place to go to in terms of what our approach will be to the drink driving matters. And each case is assessed on an individual basis. So the intention of the topic guide and the financial penalties guidance is that we have a consistent approach, but it still allows us to take account of the very individual factors of each case. So if we have a look at the topic guide, hopefully that will be clear from that.
We've had a question here regarding how we calculate income of individuals when we're setting fine levels. And just because I think you mentioned, Jackie, it was obviously, Kieran, it was obviously from income from the practice of law, essentially. And I think there's reference in some of our guidance to from other business interests, for example, be taken into account, other income. Perhaps just could you just explain that again, how we do calculate what we consider, I guess, when we look at an individual?
Yeah, sure. I mean, the intention of the financial penalty will be to be a credible deterrent. So when we are asking for financial information from an individual in order to calculate a financial penalty, we will ask the regulated individual or the firm for that information to be forthcoming from them, and that would ordinarily be used if and we expect transparency and cooperation in relation to that information being provided to us. If we had information to suggest that there was other incomes which would be relevant to the calculation of the financial penalty, in order for the financial penalty to be a credible deterrent, then again, that would be information that we could take into account when we're calculating that. And in terms of how we use that information, so it would be arriving at your specific penalty band, which gives you a percentage, and then a financial penalty would be calculated as a percentage of that income.
Fantastic. So I think we've covered quite a lot of areas today. I don't see any other questions coming in at the moment. So it's just worth saying, if you do have any further questions, maybe that we haven't got to today or come up afterwards, please by all means get in touch and let us know. So, sorry, have we got time for one more question? Let me just have a quick look. Sorry, no. So just to mention, the consultation is open until 20 September. Again, we genuinely want to hear from you. We want your feedback. That's really important to us as we prepare the final proposals, which we want to go to the board and to the LSB. So please do have a look. We hope you found this webinar interesting. As we said, there are the links you'll find under this video will give you the details of the consultation. It will give you how you can get involved and some wider supporting materials. So please do take a look at those. We really like to hear your feedback as well on these webinars. So we're really keen that you let us know what you thought about this session. There is a link to a feedback survey. It's really short under the webinar, so if you do get the opportunity, we'd love for you to give us some feedback so we can take them into account in these webinars in the future. That just leaves me to thank Jackie and Kieran. I hope everyone listening has found this really useful, and please do let us know what you think about these proposals. Thank you, everybody.